Good morning, Judge Nhlangulela. Oh, please switch on your mic.
Good morning, Honorable CJ, as well as the members of the JSC, the commissioners, that is.
Yes, how are you this morning?
Very well, thank you very much. Well treated, CJ, slept well, waking up strong and looking forward to things.
Well, I woke up at 4, so.
Some of us did not even catch a nap.
No, thank you very much. I don't know whether this is something to declare, but I just say that you and I were at university together, is that right?
That's correct, CJ.
Yes, what I can't remember is whether we were in the same class or not.
You were ahead by one class, I think.
Oh, okay, okay.
And you're a very good debater. I was
Well,
not.
I don't know about that.
You were my envy.
No, thank you very much. First of all, let me thank you for availing yourself for this interview, for consideration for one of the positions in the Supreme Court of Appeal. We appreciate that very much. We are going to ask you questions that are aimed at us seeing how you fare in terms of the selection criteria that this body has adopted for purposes of selection of judges. So I will ask you questions, and thereafter the deputy head of the SCA and the minister and other commissioners, and we might be robust in our questions, but we will do so with courtesy and respect, and nobody here intends to humiliate you on anything of that kind.
Thank you.
Thank you. You hold a BA degree and an LLB degree, is that right?
That's correct, CJ.
And you have a certificate in constitutional litigation.
That's correct, CJ.
You got your BA at Fort Hare University and your LLB at the University of Natal.
That's correct, CJ.
That is the university where we met, the University of Natal. But I see that on your questionnaire, it looks like your first job was as an acting judge of appeal in the Supreme Court of Appeal. Number 6 says, furnish chronological particulars of employment since leaving school or university. And the first one you have got is Department of Justice, acting judge of appeal, Supreme Court of Appeal.
No, that shouldn't be correct. I beg your pardon.
And you became acting deputy judge, president, and a judge, and then after that you became an attorney.
I think it's
you're meant to do it the other way around.
Yeah, it's sequence.
Yeah, no, that's all right. You became an attorney in 1993, is that correct?
That's correct. 1991.
1991?
Yes.
Oh, okay. And you practiced until you were appointed as a judge in 2009?
That's correct.
Okay. That was in Umtata?
That is correct.
Yes, okay. Please don't lower your voice. All the commissioners,
that is correct, CJ.
they are all very interested in your answers.
Thank you.
Okay. And then you became acting deputy judge president in 2014, and you acted up to 2015.
That should be 2016.
Up to 2016?
Yeah, from 2016.
Oh, your questionnaire at page 13, paginated page 13, says 2014 to 2015.
I beg your pardon.
And then there is 2016 to 2022, that is as deputy judge president.
Yes.
But it says acting deputy judge president from
Oh,
2014.
CJ, it started off by, yes, I recall now. Initially, I was acting deputy judge president, then
Yes.
moved up from 2016.
Yes, okay, all right. Okay. And then you were appointed to act in the Supreme Court of Appeal from the third term of 2022, and you are still acting now?
Up to last Friday, CJ.
Or up to last Friday?
Yes.
Oh, okay. So you are back in the High Court now?
That's correct, CJ.
Okay, all right. Okay. And how did you find your acting stint in the Supreme Court of Appeal?
Interesting judicial stuff, CJ.
Yeah?
Very interesting. I found it interesting and edifying and educating.
Yes.
It's a true lift in terms of quality of work.
Yeah.
Yes.
Yes. And in terms of your length of service on the bench, you have been a judge since 2009. That makes it, what, 14 years now?
That's correct, CJ.
Yes. Okay. Okay. And the types of matters that you found in the Supreme Court of Appeal, how different were they from those that you would normally handle in the High Court?
Naturally, CJ, the Supreme Court of Appeal being an appellate court, naturally the work that is done there has to be different. And if one has regard to the fact that the work being done there is drawn from various divisions, the general divisions of the high courts. So it's in a manner of speaking, you get the best cases from the general divisions being litigated in the Supreme Court of Appeal at the level of them being appeal matters. So they would naturally be different. It's not a general division kind of thing. It's completely different. It's an appellate court in a true sense.
And in terms of branches of law as well, is that correct?
Lot. There's a lot. It's interesting. I recall that in our discussions, we normally say there is no court at which one, as judge, you would find the mixture of a law that is being evolved in that court.
Yes.
It's really interesting.
Yes, yes. Okay. And your acting stint was ultimately four terms?
That is correct, CJ.
Yes. And then did that give you quite a lot of exposure to different branches of law, experience and appellate experience?
A lot of it. I may also make this point up front, that the appellate experience, it being the equivalent of the full bench or benches that we have in the general divisions, it would be operating at that level. Of course, the difference being the type of work that we do there. So it's more of researching if you are in the Supreme Court of Appeal. And I may say that that is what I found interesting, to be researching, looking for new knowledge, opening up spaces that one has never been exposed to before. Yes.
And of course, in the Supreme Court of Appeal, I would assume you had nothing to do with administration. Did you miss administration?
That is
back
what
home as
that
TJP?
certainly not. I think if you examine my profile closely, you will see that people speak of me as a hard worker. I think that is what I enjoy. You know, that challenge. Oh, let me put it this way: I'm not afraid of that challenge.
Yes. Okay, all right. I'm not going to say that if at some stage you seek a position that has a lot of administration, we will remember your answer.
CJ, I think the best way of putting it is, we'll cross that bridge when we get to it.
Yes. Now, in the High Court, have you had a lot of exposure to cases where you are called upon to declare legislation constitutionally invalid?
I wouldn't say a lot. Such cases are a rarity, that is in the general divisions. I make this statement being informed by the developments right across the division, not just at my station in Mthatha. If I look, of course, being informed as the administrator in general division, one hardly gets cases of that nature, but they do okay. I won't say that they don't happen. They happen, but it's a rarity.
Well,
but nevertheless, CJ, I do know something about it. The principles involved.
Yes. Well, it's interesting what you have said, because it aligns with my observation that it seems that many judges at High Court level do not come across that kind of work, and yet it's quite important that they should have that exposure and that experience, which obviously would be important if and when they move up to the Supreme Court of Appeal, and particularly the Constitutional Court, if they end up there.
That's correct, CJ. More so in that this is an item which is very relevant to the aspect of the jurisdiction of the High Court. It's vested with jurisdiction to decide cases which sound constitutional in nature, and for that reason, it wouldn't be something one might describe as strange. Yes, in terms of practice itself, we don't come across a lot of those cases, but we are aware, we are on guard that should a constitutional issue crops up, one will have to wake up and take out of the drawer those tools of trade. I wouldn't say we are not armed. We are armed, and it's something that we have to be alive to all the time.
Yes. Well, you did say that even though there aren't so many matters that you have come across, excuse me, practically, you are aware of the principles. Would you like to share with the commissioners what you do as a judge when you determine whether legislation is inconsistent with the Constitution and therefore invalid?
Thank you, CJ. It starts off with the power that is defined in the Constitution itself, also that the High Court does have power to consider the validity of legislation in terms of whether it is constitutionally compliant or not. And that exercise extends to even deciding the merits of a constitutional point, save, of course, that if the High Court judge happens to be confronted with and is determining a constitutional point, it will do so, and after doing so, refer the matter to the Constitutional Court, because the Constitutional Court is the final arbiter. It is the one which will have to confirm that Judge so-and-so, you were right. In fact, as a matter of the hierarchy of the courts, the Constitutional Court being the apex court and being the specialist court to express itself on constitutional matters, that is what would happen. Of course, there would be a number of things that the judge who so refers the matter to the Constitutional Court for confirmation to do. He would have to perhaps decide whatever collateral aspects as not touching upon the heart of the issue, decide them on interim basis if the case itself so requires, and suspend that order of invalidity of the act under question, or just conduct under question for confirmation by the Constitutional Court. There are a number of things, just like also something that we do even in petitions. You write, you're in the normal course, the reasons why you are referring and so on, and why so that the Constitutional Court knows what the take-off point was and what the direction was, and more so what the real issue to be determined must be.
Okay, I'm more interested in the stage that precedes the actual conclusion that the legislation or a particular statutory provision is inconsistent with the Constitution and therefore invalid, and way before you get to suspending the order or not suspending the order and so on. I'm just more interested in these are the questions you ask yourself that will lead you to deciding whether this legislation is inconsistent with the Constitution or not. Is that something that the principles that you are familiar with, do they deal with that?
For lack of practical experience, since these matters are a rarity, I would be guessing. I imagine that there are certain things that one would have to look at. For an example, since courts generally are guided by pleadings, the constitutional point must be identified before talking into it could commence. It must be clearly identified. So that it is known what it is that requires. You might be making a mistake thinking that there's a constitutional issue when none exists. So the interrogation becomes important. Naturally, counsel will have to bet on it, inform the court about where they come from and why they think that this is the issue that might require a referral to the Constitutional Court at the end of the day. I will not be able to delve more than what I've said into what the practical aspects on the ground should be. I beg your pardon.
Yes, no. I understand. The disadvantage is the fact that the High Court doesn't seem to have enough of these types of cases for many of the High Court judges to come across them and do them, and therefore gain experience. Let me ask another question that is not so much into the Constitution. There are two types of discretion Are you familiar with what they are and what the differences between them are and what the legal significance is of those differences between them?
When one speaks of a discretion that is made by a judge, one immediately gets transported to the decisions that get made at various levels, because discretion is a decision that has to be taken in a particular manner. For an example, if one is dealing with an executive decision where a discretion has been exercised on policy, the approach would naturally be different, because the test there would be the principle of legality. If it's a purely administrative decision that one has in mind, then different rules would apply there. And also there is the discretion that is applied on virtually every day by the judges in the general divisions, especially when it comes to criminal cases, sentencing, and so on and so on. So the discretion that gets exercised would be wide in one instance, and in another instance it would be restricted by the requirements of the decision that has to be made.
What is the legal significance between the two?
The legal...
In other words, why is it important for a judge to be able to identify which discretion he or she is dealing with in a particular case and which discretion he or she may be dealing with in another case?
It's what underscores everything is the power that is being interrogated. In analyzing the power, different routes are followed. It's not just one pathway, because the power would be informed by the situation of he or she who decides, and linked to that would be the authority of the court in terms of whether it can interfere with this discretion or not interfere with that one, as informed by the principles of interference that inform the exercise. So basically, it is the power that is being exercised. The discretion under question is what is a determining factor, in my opinion.
I will now give the opportunity to the Deputy President of the Supreme Court of Appeal to put questions to you.
Thank you, CJ.
Thank you, Chief Justice. Good morning, Judge Nhlangulela.
Good morning, Deputy President.
You were asked earlier on by the Chief Justice for how long you have been at the Supreme Court of Appeal, and your response was that it was 4 terms. Is it not, in fact, 5 terms?
Okay, I've got a document here. May I verify? It was October, November 2022, and it was February, March. That's another term. Second term, February, March 2023. It was April, May 2023, and the final was August, September 2023. So these would be 1, 2, 3, 4, I think.
Okay, it's not from the 15th of August of 2022.
Yes, it was. Oh, yes, it was. Yes, it was. Yes. I beg your pardon. Yes, it was. I remember arriving there at the beginning of the month. It was in August, to prepare myself. Yes. Thank you. I beg your pardon. So that would be 5 terms. Thank you very much for that assistance, Honorable Deputy President.
I've had the benefit of reading comments from various legal bodies, the GCB, Law Society of South Africa, NADEL, BLA, and the one that I'm particularly interested in is the letter from a Mr. Nkosi Vumile Makanya, who is an attorney in East London. Were you provided with?
I was. Thank you very much. I'm looking at it, DP. I've got the letter, and this was my initial reaction, if I may read the few words that are attached to that particular comment. I said, I have noted the overall support that he gives to me. I was referring to Mr. I know Mr. Makan, that he gives to me. I defer his comment that my candidature might have betrayed the aspirations of the legal community and the people of the Transkei region to the JSC for consideration. At first glance or blush, one would find Mr. Makanya who's saying Nhlangulela is not fit and proper to be appointed in the SCA. On the other hand, you find the same person saying, no, this is a good candidate. He can compete, he is good. And how he does that, he says that I've been doing sterling work in the General Division, and he himself says he likes my commitment in that division. And ultimately he then says, but I would prefer that Mr. Nhlangulela stays on in the General Division. Because I'm a candidate, I choose to go with the word that I'm fit and proper, and even the statement that even if I were to stay in the General Division, I would be doing well, as I've always been doing well. It's a positive comment overall. The negative, there's very little that is proffered in support of the reading that I can describe as a statement of non-support. I can't really find the true basis for that. So that's where I'm situated, DP. But because I'm a candidate, and from his comments, I would like to choose that which supports overwhelmingly my candidature. That's as far as I can read his. May I also say something about this particular gentleman? I remember again when I appeared before the JSC for the purposes of an interview for a post as judge, he more or less expressed himself in this fashion.
Judge Nhlangulela, I'm sorry to interrupt you.
Yes.
I think we would make better progress if you allow me to pose my questions to you and you can respond. If you want to elaborate, by all means.
I beg your pardon, DP. I beg your pardon. I thought I was giving the role. I beg your pardon. I'm so sorry.
Thank you.
Yes.
The way I read Mr. Makanya's letter is that he says you are doing sterling work in the division, and they would want to retain you there so that, you know, ultimately all the challenges confronting the division are resolved and are a thing of the past. And for that reason, as I understand it, he is not supportive of your candidature. And the proposition that I want to put to you, in view of the fact that he recognizes that you are doing sterling work, you are a hard worker, shouldn't that rather count in your favor instead of against you?
Thank you, TP. I'll make this submission. I would say, rather, I would make a request that that comment may, for the purposes of this interview, be regarded as an unwavering support. I can't read it any way different from that, and for which I'm thankful. I agree with you entirely, Honorable DP.
Thank you. Let's then go to the questionnaire. Paragraph 16.1, which asks each and every candidate to list the cases where you have written judgments which you regard as being most significant. You have listed those judgments. It said, paginated page 17.
I'm trying to get there. I beg your pardon.
And please indicate to me once you get there.
Yes, I beg your pardon.
You need to locate the questionnaire and then go to paragraph 16.1.
Yes. My document, TP is, please assist me. You know, and I learned immediately to the names of other people. Because my name is there. Oh, okay. Okay. I beg your pardon, I have two books in front of me, but I've got the relevant one. I'm there, Honorable DP.
Thank you. As you will observe, you have listed 10 judgments.
Yes.
But what you have not done is to indicate why you regard those judgments as significant. And this is now your opportunity to enlighten this commission as to why you regarded those 10 judgments to be significant.
Firstly and foremost, I must apologize to and the Honorable Commissioner CJ and the DP that you don't have
Please try and speak up.
Thank you, CJ. I apologize to the commissioners as well as CJ and DP for the fact that you don't have those summaries up front. I apologize. The negative was never intended. May I take the opportunity for which I thank you, DP, to mention a few words about Penrose Ntamo and 4 others versus the Premier of the Eastern Cape and 6 others. This case is a very important one in that it carries the principle of the right to vote and the nuances that one comes across it when it comes to the practice of customs, especially in the area of the Transkei region, where you would find one practice on the side of the river being different from the practice in which headmen and chiefs are appointed the moment you get to the other side of the river. This is an item of democracy in action and something to be supported, and to the extent that when people have been so able to express themselves on such an important matter and succeeding to persuade other South Africans, and including the courts, that the system in which that is we use in appointing the traditional leaders is peculiar to our area. Those who know that area would be fascinated by the history of the Kala Reserve, the dynamics, and if you want to understand what the power relations are when it comes to South Africans in the old and especially the old South Africa, which was underpinned by apartheid, one gets to appreciate those dynamics without ending in Kala Reserve. But that development there, or the dynamic there, throwing light to what is happening elsewhere. So this is, in fact, if you look at that case, there is a quotation that I made. I made an interesting discovery in the backing of this voting system in the Kala Reserve by Professor Nsebeza, who outlines the history so eloquently and in the manner that, it kept me in. So I felt that this is one of the discussion in this case that might be interesting for this forum, but not only for this forum. If you want to understand the dynamics of the country, you need to know, amongst other things, what the developments in Kala Reserve have been. That is why I picked on that case. It was interesting to me, and I felt that sharing it with other South Africans would be helpful. The case of Mtokonya articulates a very crystal principle of prescription of a claim, and what it's not only that this case was confirmed by the Apex Court, which made me to bring it up. Of course, one of the factors, but in the main, it was a lesson for the litigants that the manner in which you plead your case is essential. And you might find it very easy to let down your own client. It's an aspect of lack of preparation It's an aspect of imperfections in the legal system. Yes, if you want to think about it as having happened in this case alone, but it is not so. And I wanted to make the submission that it's an exception to the general rule. Generally, one does not, as a lawyer or as member of the community, like to see a claim by a South African being denied on the basis of prescription. But this is one of the cases in which it became unavoidable for the claim to be denied. It's education, education, and education. As human beings, we need to interact with such matters going forward. The Busuku versus RAF matter, again, it's Honorable DP, do I proceed to Busuku or I wait?
Yes, but just briefly, just state the importance of the principle
Yes, thank you.
involved in each case, and you need not deal with the facts of the case. Just briefly, succinctly state the principle.
Okay. In Busuku, the principle the case articulates is about the special point which was raised in limine, which was dispositive of a very important aspect of the case. That is in TDH solo. That is in Busuku. The case is about RAF claim. It's about prescription again, a matter which touches on a constitutional right of a citizen to take advantage of the RAF pass that is available to those who are involved in motor vehicle accidents. In Maqaya, the reason I put this case up was to indicate the sensitive nature of the claims against the Department of Health, if one has regard to the deluge of these claims which have undermined the purse, or let me say the budget of the health department. And not just that, it also highlights the worrying imperfections in the hospitals. Strictly speaking, this case is, should have been won by Maqaya, but we find those things. In Matimba, this claim, in this claim is the opposite of Maqaya, in that the claim was successful there. In Bezak, the issue there was about the protection of rights of ownership. And how that the servitude that was discussed and approved in that case protected the rights of owners, as well as protected the deeds office insofar as the rights are registered there, and which would have had to be deregistered in a way that was never that is experienced in the Republic. I think it articulates that principle, that is the protection of rights of ownership of property. Makwele, that is a case which is about the appointment of a headman, again, the succession plan, and the manner in which the matter was decided at first based on untested history, when the administrative law issue, which was dispositive of the case, should have guided the courts. In Mapukata, I would like to submit that there's nothing special about that case, that is Deputy President. Plagis, this case is put up in order to reflect the assistance the judge can derive from a proper analysis of the pleadings. If a case is pleaded badly, a very important claim can easily be lost. This case is a demonstration of the ability on the part of the judicial officer, who happened to be me, to have been able to identify the true issue, analyzed it properly, and saved what is claim for an available claim for the plaintiff, who happened to be a woman who suffered in the hands of violence of police officials. Overall, it's my experience is something that touched me as I was dealing with the cases, and in the conversation that we have today, I felt that this interaction might be helpful. It might be an eye-opener, as it were. I'm a very compassionate person as a judge, by the way, members of the commission. There's nothing that I believe in more than treating the citizens with respect, and where you have to go an extra mile, you do so, and you protect their rights. That much is what I'm able to say, Honorable DP.
Thank you. Still under the same paragraph, of the 10 cases listed there, only 2 from the Supreme Court of Appeal.
Thank you. Can I come on?
I didn't hear the response, Judge Nhlangulela.
Oh, thank you.
Just need
Thank you.
confirmation.
Yes, may I?
Thank you. And you signed the questionnaire on the 16th of June 23.
Yes, thank you.
And by that time, given that you have been at the SA over 5 terms, in the ordinary course of things, you should have written a minimum of 4 judgments.
Yes. This point, thank you. This question, DP, it ties with the point raised by the GCB, and there's an explanation to it. The cases that I dealt with, in which I was scribe, were 6. There were 5. 1, 2, 3, 4, 5. There were 5. Then I managed to complete this one, that is Bezak, and the outdoor one was delivered, and I may say that in the discussions that we had in the panel, it was felt that another colleague must write the judgment. The dissent should prevail over the judgment that I had written. In fact, I soon realized after doing research and writing that I missed an essential point. And in the spirit of collegiality and in the manner in which we work in the SCA, I felt that what is honorable is to respect the dissent. The dissent, by the way, is as important a judgment as the main. Then I decided to go with the dissent. In fact, having been convinced that a license holder, that is the case of outdoor, a license holder is not entitled to keep two premises in which he keeps the firearms that he trades in. You can only do so only in one premises. In other words, the license is determinative, something that I had missed. I did not even write this case here because I did not write it, but I'm pleased to mention this because if you speak about debates that happen in the panels, this goes towards the positive side. And cooperation and awareness. It does not matter when you become aware, but what is important is that as soon as you become aware, you must raise the hand. It's not about your own integrity, your own ego. It's about the court. It's about the judgment. In fact, those who led me there used to say, this is the judgment of the court.
My interest was more into seeking your confirmation, whether in the light of what I've put to you, that namely, by that time you should have written 4 judgments to confirm whether in fact it's 2 and others are still in the pipeline.
That is true. That is true. And DP, I'm sorry, I get moved by some of the developments. I'm sorry. May I say there's a case of Pile. At the time, it had not been delivered. It has since been delivered on the 27th of July 2023. That one has since been delivered. And before I pass on to the next case of Moloto, 2 cases in Nabolisa, may I say something about Pile? Because it's important for me. The case having been heard on the 2nd of May 2023, I being scribe, and I having been able to circulate the judgment on the 21st of June 2023, I think that I did what was expected of me. Beyond that, it was a question of what does the panel think? You know, there are debates where the scribe does not alone control the process, and it is important. I may also alert you that judgments in the Supreme Court of Appeal are a serious business. All the members of the panels, they commit themselves to the hilt in an attempt to ensure that the principles of law are not lost. As I've said, that court serves as a guide to many other courts below it, the general divisions and so on. So it is important that an opportunity is given to members of the panel to work hard to ensure that that final product which goes out is the correct one. That's a normal exercise. But for my part, because of the knowledge that if you are scribe, you must wake up, you must write your judgment fast, you must work hard, don't sleep at night, work and then say, this is the work that I've done. I did that. And in the case of Moloto versus PAC, unfortunate, this is unfortunate. The case was heard on the 24th of May, 2023.
Judge Nhlangulela, I have to interrupt you. We shouldn't go into details about judgments which have not been handed down yet.
Oh, thank you. Yes. May I end here? The other two, Moloto, although it's circulated, has been circulated, but not yet out. Nabulisa, which is not here, in which I'm scribed, it has also been circulated, but not yet out.
Thank you. Let's go to paragraph 16.2, where you have been asked to list cases that have been reported, and you have listed 7. That is same page in the questionnaire.
I see it, Honorable DP.
Do you see that list?
I see it, DP.
Only one being the last of those judgments where you have given the full citation in which law report the judgment was reported, and the rest, no indication.
I know that may I start from the top? That is point number 1, just to explain. In Penrose, the matter went on appeal. I did not sit in the appeal, but that one was reported. That is the appeal in which there was confirmation. The same goes, these cases are being reported only in Safli. The same goes in Togonya, reported in Safli. I've not seen it being reported elsewhere. Busugu, again in Safli. TDH was reported in Safli. Magaya also was reported in Safli.
So all of them, bar one, have been published in Safli.
I think Bezak is all South African law reports. I think it's. I've seen it recently. That is long after I put it here, that it was reported in all South African law reports. I've seen this one.
And my last question to you, Judge Nhlangulela, is, and I'm mindful of the fact that this might not be easy for you, but I need to put it to you nonetheless. If you do self-introspection, self-assessment, given that you have acted at the SCA for 5 terms, are you in a position to say to this commission, you are truly suitable for elevation to that court?
Thank you for the question. I must be honest. During the first 2 terms, I did feel that my engagement was not enough. But as I progressed up to my last acting stint, I really felt confident, so much so that I did not feel any regret that my coming up for this interview would be misleading to South Africa. I really feel that I'm ready and that I can do work in the Supreme Court of Appeal. That's my honest assessment of the matter. And I have made this introspection with regard to my entire record in the judiciary. I think that I've been appreciating how I've developed from one point to the next. This has been a journey, not started in the last 5 terms, not started in the last 1 year. It's the journey that started from 2009 and even before 2009 when I was an acting judge. The engagement has been thorough, and I believe that the type of training the type of experience that I've acquired is one that would make, I submit with respect, me a fit and proper person to work in the Supreme Court of Appeal as the justice there, as is envisaged in Section 174 of the Constitution. I can't come here and tell lies. I know what I can do. I have to declare the negatives. To that extent, I would not be having any other negative, save the only one in outdoor that I have declared. And also, I've looked at the provisions of Section 165, and based on the same submission that I've made, I think that I fall within the ambit of Section 165. Appropriately qualified as a judge, and I think that I'm independent enough to be in charge of the work that I do, of course, being appropriately connected to my other colleagues. I'm aware that this is not, my independence is not a one-man show. It's something that can only come to fruition if it is properly tested and having worked in the environment of other colleagues in the judiciary.
Thank you, Judge Nhlangulela, and thank you, Chief Justice.
Thank you, Minister.
Thank you very much, CJ, and good morning, Judge Nhlangulela.
Good morning, Minister.
Yeah, no, I know that you served in the National Council for Correctional Services. How do you think that has enhanced your work as a judicial officer?
It did a lot, Honorable Minister, a lot in the way that I cannot measure by artificial means. Minister, a judge is an embodiment of a lot of features other than the determination of whether this case has jurisdiction to be entertained by me, or whether this delictual matter should go, this claim should go this way or that other way. And having been exposed having done work in the National Council for Correctional Services and dealt with the parallel community, something that I became aware of, the members of the commission, I'm happy to inform you that I knew for the first time in my life, it's not a secret society, Minister, but we have a society comprising of so many South Africans who are languishing in the prisons because of the levels of crime. What? The absence of appropriate education to extricate the poor people from the tendencies of committing crimes every day. We are faced with that is what it taught me. That is what it taught me. It taught me some aspects of sentencing, which have not, by the way, Minister, have been appropriately infused with, that is in our system, in our broad system of sentencing. That is what you do with the rehabilitation systems and the benefits which prisoners acquire there. Do we have a lot of them being taken back to the sentencing court for their sentencing to be reviewed? It does not happen every day. I work in the General Division. I don't see it. I'm not blaming anyone, but I know, and thinking about this situation, I feel every day that there is a job, a huge job ahead of us that we need to do. In a nutshell, I've benefited, and I think I know the direction which society should go to if it has to alleviate the problems we have in the prisons, especially crime.
With that experience, Judge, having served in that body, what do you think should be done to improve the parole regime to help with the reintegration of the inmates back into society so that they also, in terms of their changing behavior, be positive role models in society?
We need a multifaceted approach because we are dealing with human beings. I've mentioned one, that if the fate of those who are incarcerated was not to be left with the Department of Correctional Services, if only we could understand that this is not the function of the ministry to take us out of this problem. It's a problem which is more inviting, but many people, I know that they are not aware because they do not, they are not connected to the prisons on a daily basis. They do not know that there is a society which has been created by us, which is stuck into the prisons. So it being a multifaceted approach, it's just the connections, Minister, and that is with the social workers, psychologists, and this extends, of course, to the courts. I've mentioned the courts. The courts, I think that they're not well connected to the penal system because it tends to have a limitation at saying, once I have convicted and sentenced this prisoner, that is it, I'll never meet him again. But I know that there are other bridges which are present in the Act, Corrections Act, which have not been explored fruitfully. I also know it, Minister, I've attended even the budget speeches, I think 3 or 4 budget speeches, where I observed our brothers and sisters belonging to various parties debating about the expenditure, and when a call is made about the expenditure being made better, I mean resources, when I say expenditure, not just money, resources at prisons, that's very, very necessary so that we can resolve the problems that we have there. It's the shortage of interventions which are kept at bay by issues of resources, as a result of which the task, Honorable Minister, it looks like to a person walking in the street that the ministry is responsible for not doing a thorough job in the prisons. In fact, it's not the function of the ministry alone. In short, the department is doing a sterling work, but short of further interventions, and that is owing to the resources that South Africa does not have. We still have, but we are at a developmental state. Can I
interrupt Judge Nhlangulela? Please try and give brief answers, and they shouldn't be too long.
Thank you.
Okay.
Thank you. Thank you. I've made my submissions. Thank you, Minister. More interventions are required. More budget resources. That's it.
Yeah, thank you, CJ.
Thank you. Commissioner Dodovu.
Thank you, CJ. Good morning, Judge Nhlangulela.
Good morning, Mr. Tutu.
I want to draw your attention to this case that you're talking about of Penrose Ntamo,
Yes.
where you reviewed and set aside the decision of the Premier of the Eastern Cape to appoint a headman, because as I read your judgment, you argued that the customary law was not followed, and that they followed the Traditional Leadership and Governance Framework Act more than the customary law, as I understand. And therefore, that served as the basis to set the decisions, to set the decision aside. Why, in the light of that, you didn't also declare the Act, the Traditional Leadership and Governance Framework Act, unlawful on those bases, because it conflicted, in your view, with the customary law?
There is thank you, Commissioner Dondo. There is an underlying principle when you deal with cases such as this, which is present in this case, which says that the decision to appoint the headman being an administrative decision, you then allow existing administrative decisions to stay in place until they have been set aside. That's a very fundamental principle of law. In a nutshell, that did not happen in this case. And when I argued about the custom, I was saying as a result, the first decision, which was premised on the custom respected by that community for many years, was not given recognition. So it's not that the act in itself is invalid, it's the application. There's no controversy about the act, it's just the application. In a nutshell, the respondent, the MEC and the Premier, they simply jump the gun. Now, what is important about this case is that, okay, we see that happened, administrative decisions were not accorded the respect, the legal recognition that they deserve, that's fine. But in this case, there's an interesting story. The custom, the voting custom, the electioneering in that region, something that you don't find elsewhere. Let me just mention this one. What is commonplace in traditional communities is the hereditary system. So just to juxtapose it with this customary consideration, it was something novel to find something that ties up with our constitutional democracy in Ala Reserve. And to that extent, it was necessary that one brings up and gives recognition to this custom.
But Chief Justice, you might follow up. But if I read that judgment, the issue is not about hereditary, as you say it now. It is about the community embarking on a participatory process to appoint their own headmen and follow the process, refer that to the traditional leader, and thereafter refer that to the Premier of the province, who must assent or agree that this is a rightful person. It is not about heritage in that sense, traditional heritage. It's about the process that was embedded within that community over centuries to elect their own headmen. And for me, I find it a bit confusing, and that is why I seek your indulgence in this regard.
Yes, Commissioner Dodovu, you have hit the nail on its head. That was the problem in that case. Non-recognition of a customary principle, in a nutshell.
Thank you, CJ.
Thank you very much. Commissioner Marumwakhaya.
Thank you very much, CJ. Good morning, Judge.
Good morning, Commissioner.
I initially had two questions for you, but I will discard one of them and then just ask another that came from your interaction with the DP. It seems to me, and correct me if I'm wrong, that judges generally, at least from what I've experienced since I became a member of this body, seems to struggle with reported judgments and judgments that appear on SAFLI. I just want to understand, what is your understanding of reported judgment? What does it mean to say that a judgment is reported?
Thank you very much for that question. That question it's revealing. It reveals this. There is a problem in the law that we practice. I'm taking it at the level of practice, not judicial. It's just starting there. And the past. We had two centers of practice, the bar and the sidebar. And the attitude prevailing at that time up until today is that this is an attorney, don't worry about his decisions. Now, this thing has...
Sorry, Judge.
Yes.
I really apologize for this. I think let's take it on what it is. Perhaps maybe the point that you are making is valid, and I don't want to trivialize it. But I think, because now I'm trying to save time, let's say you write a judgment now, and that judgment appears after 2 or 3 days on SAFLI. When that judgment appears on SAFLI, the way we use the word reported, would that judgment be regarded as reported? I think that is the essence of my question.
I wish, thank you very much. I wish I knew how to answer you directly. I'm not able to, because these are platforms that are not under the control of the Office of the Chief Justice, or if I may put it, judges. It's a commercial entity doing its own business, and if we recall, even the OCJ has expressed itself repeatedly on...
I'm sorry, Judge Nhlangulela, let me intervene,
Yeah.
because we want to make progress. Essentially, what you are being asked is your own understanding of what it means when somebody says a judgment is reported. Your own understanding. Leave out what somebody else's understanding may be.
No, thank you.
Your own understanding, what is it?
Thank you. Traditionally, before SAFLI came, the understanding was that it is the South African law reports which is regarded as the platform for reporting of judgments.
Thank you very much. My last question to you, I just want you to, now you are a judge, you are sitting at the Supreme Court of Appeal, and you have an application before you for appeal. And in that application, there has been, or there are overlays that are made that the litigant wishes to advance or to provide further evidence. One, is it allowed for a litigant to provide further evidence? If so, what is the test that the court should assess when assessing whether or not to accept further evidence? Thank you.
The answer is it is allowed. Our practice does allow it, that further evidence may be admitted into the record, provided that the test is passed. And the test generally is that it must be shown by he who wants new evidence to be introduced to explain why this new evidence was not available at the beginning. So we undertake an evaluation exercise, and we also take into account the relevance of that further evidence. And we also take into account the prejudice that further evidence might create for the other party. And that is the extent in which we as judges have to make the evaluation. Of course, acting on the application which is before the judge, but we do it. Our system of hearing of cases does allow it, and we do it. There are no hostilities about the admission of such evidence.
Thank you very much, Judge. Section 19B of the Superior Court Act deals with that. But anyway, thank you very much, CJ.
Thank you. Commissioner Steinberg.
Thank you, CJ. Morning, Judge.
Good morning, Commissioner Steinberg.
I'm over here. I don't know if you can.
Thank you, Commissioner Steinberg. Oh, thank you.
I want to pick up on the last question that the DP asked you, and that's your readiness for the SCA. The SCA is a court of appeal. It writes judgments that set precedents for all the high courts in the country. And I have three observations in that regard. The cases of significance that you point to, I don't see in any of them anything that grapples with difficult questions of law. They appear to me factually interesting, but pretty run-of-the-mill reviews, criminal appeals, etc. The law reports, the previous question you were asked, the law reports publish judgments that create precedent or develop the law or grapple with novel issues of law. Your judgments, and I'm excluding the SCA judgments because those are not ones you've written on your own. I don't see any sense in your judgments of looking at those issues or considering those issues. Finally, when you're asked in your questionnaire of what you regard as your most significant contribution to the law and the pursuit of justice in South Africa, your answer is to give access to justice to all South Africans, regardless of their skin color, race, creed, station in life. This I do by keeping the doors of the court opening, listen to people, delivering judgment with expedition, giving hope. It seems to me that is the function of every single judge and magistrate in this country. Nothing more and nothing less. The oath of office and to work diligently. So when I put all these factors together, I'm failing to see what qualifies you to be a judge in the appeal court of South Africa.
I concede the observation, Commissioner, and given that I have to respond with what I have in front of me, and cases in which I have spoken, I will not be able to add to what I've said, and at the same time, it's not necessary for me to be critical. It's an observation. I accept your observation, and that much is what I can say. I can't put it. In fact, there's another just one aspect I want to, I might perhaps sensitize you about. You know, when it comes to these issues, I've also been asking myself the same question as to whether, if I was situated in a court other than Mthatha, you know, the location of the judge does account for such things. That much is what I would like to add in this discussion. What am I saying? If I decided to go and work in a busy court, highly commercial court like Johannesburg, just to make an example, I surely would have been in that mix, and I probably would have presented a picture. It's the shades. We are dealing with shades here. If you are located there, you have to live with what you have. But now, in the final analysis, does this circumstantial prejudice have to disentitle me as if I made a choice? You know, just to add into the mix, it goes into the mix. I'm not taking anything away from the commissioner. I'm not really being argumentative, but that much is what I'm asking, that it should be thrown into the melting pot.
CJ, can I please follow up on that?
Yeah, okay, maybe then we'll come back to her. It's okay. I'm assuming she doesn't have a follow-up. Okay. Okay, all right.
Thank you,
I just
CJ.
want to be recognized at some point, CJ.
No, I've been very bad at recognizing people, commissioners this morning. I've been helped by other commissioners. Okay, thank you.
Thank you.
Commissioner Baloyi.
Thank you. Good morning, Judge.
Good morning.
Yes, taking from your statement about circumstantial, your geographic location, it being a limiting factor. My concern is, looking at the judgments that you have given us, even accommodating or allowing for your place in a particular geographic area, that I have concerns about whether you engage enough with issues that are complex, that are presented to you. For example, in the Ndamo matter, you hardly engage with the submissions about the application of PAJA in deciding the matter. You decided solely on the facts that historically customary practice is that the community votes. That's purely a factual determination. You make passing reference to the provision in the PAJA, in fact, in particular, that council has said this. But one doesn't see your reasoning about it, which reflects your understanding of how that gets implicated. That's one. And then two, in the Janji matter, which was successfully appealed, Janji versus Rhodes, we don't have the benefit of your judgment. That your judgment was set aside and the appeal was upheld. And there the SCAs applied PAJA. So on the basis of PAJA, she was entitled, that student was entitled to procedural fairness to be there. Now, without the benefit of your judgment, one must assume that you found she didn't have the right to be heard, at least deriving from PAJA. You didn't find that. And for me, that's problematic if you're going to be sitting in the SCA, that one doesn't have a sense. In fact, you seem to, taking from the earlier discussion with the CJ about not having had the opportunity to deal with legislation, constitutionality of legislation, that it seems like constitutional law is an area that you're uncomfortable in, and if that is so, that would be a matter of concern for you to go sit in the SCA at this point, at least. Do you want to say something about that concern that I have?
As I appreciate the question, it's the presentation. the presentation is there on the document. I don't think that I would be fair to engage the commissioner any differently on this. It's the presentation is there. If the presentation does not make matters clear, in fact, as I'm sure you had me indicating to the previous commissioner that, look, in the background, there is a question of PAJA compliance, but the issue in that case was custom. Maybe it's just a question of the presentation, which was bad on my part. Judgments are written and at different under different conditions and so on I appreciate what I'm trying to say, Commissioner. I appreciate your point. Yeah.
Thank you, Judge. Thank you, CJ.
Okay, just a quick follow-up. I think you've had golden opportunities to look properly at the relationship between PAJA and customary law. These are cases which deal with that intersection. And it's precisely because you sit in the Eastern Cape Court, I think, that these come to you. So I accept that the nature of cases that come to you in other provinces is different. But I think you've had opportunity, and it's not a question of presentation, it's a question of the substance of the law.
May I say something?
Yeah.
The result, Commissioner, the result. Thank you. The result, it also counts.
I'm sorry, just repeat that answer. I'm not sure I understand.
I was saying I've highlighted the aspect of the melting pot and how that it may be necessary for one to throw in other aspects of the discussion in this consideration. Now, I've just raised the point that the order also counts. What I'm trying to say is if a man is tried for an offense, I'm just illustrating my point. Tried for an offense which requires him, upon conviction, to be sentenced to murder. Debates may be raised by me in the judgment, however I present them. But it counts at the end of the day that this man who's innocent, whether you use reason A or reason B or reason C, has not been sacrificed by a wrong order in the final analysis. That's just the point I wanted to make, the order that was made.
Yes, but you do appreciate, don't you, that both the point that was being made by Commissioner Baloyi and I think Commissioner Steinberg, or part of the point, is that here was a case which presented you with an opportunity not just to deal with the matter in the context of customary law, but also of PAJA, but you didn't use it. So in other words, you could have situations where, because you are located in Umtata, you don't get lots of cases that relate, that deal with certain types of matters. But when you get it, somebody else could have grabbed that opportunity with both hands and written a judgment that dealt with the intersection between customary law and administrative law. That's part of the point they're making, that you didn't use the opportunity.
That's correct, CJ. I've appreciated that. I can't make my points. I can't add more. I've appreciated that. I'm thankful for this discussion. I'm not taking the point or points raised away. I'm not minimizing them. I'm glad to hear that there is this aspect which I might have approached differently.
Yeah,
I appreciate that.
thank you. You're done, Commissioner Steinbeck? You are done, okay. Obviously, all of us commissioners, as the interview goes, we continue to reflect on whether we really want to ask certain questions. Maybe questions change because of answers that are given and so on. Commissioner Poswa Lerotoli.
Thank you, CJ. Good morning, Judge.
Good morning, Honorable Commissioner.
On the last occasion you appeared before this this body, that would have been around April 2017, you had availed yourself for the position of Judge President of the Eastern Cape. Is that correct?
That's correct, Commissioner.
Now, on that occasion, a number of problems, in fact, a litany of problems were raised about the functioning of the court and the problems around, in particular, the court in Umtata, which you head at this point. Do you recall that?
I recall this, yes, Commissioner.
Yes. Now you are seeking elevation to the SCA. About 6 years later, do you feel that you will leave behind a healthy, functioning court? As if you are elevated, what is the position today?
I would like to respond this way, without sounding offensive. I'm here today not about administration. Okay, then may I then attempt to answer the question directly. That was a hectic process. We all observed it was a hectic process, and after it all, we came out of that process with a solution that Judge so-and-so, not in Nhlangulela, should be the judge president. That was informed by credible information in front of the commission. I accepted that. And then we started what I would regard as a new regime, in which I was very much a part as well, because it didn't mean that after that meeting I had to go home. And the important part of me is that, having accepted that there was a need for a solution to be found, and which solution was found, and then the new journey started, so to speak, in which I was a part and which I supported fully. We then, together with my colleagues, this is not a journey of one person, a journey of members of the division, having become, all of us, not just in Nhlangulela, become aware that there are things that we have not been doing properly. Then we regrouped, and on the new journey, we made improvement. And as we speak today, I personally would not suspect that there is anything wrong since that day that is affecting the division adversely. And when I say division, I mean the entire division in which Mthatha is a part. Mthatha is not a separate entity, it's a part. It goes together with other parts when one speaks of administration. I'm just sharing this information so that we are alive of the strides that the division has had to make since those observations. And I'm not able to say today that we failed in that endeavor. Personally, I would allay fears that there's anything further of the nature that was discussed then, which is wrong about the division. When I say wrong, I'm referring to the administration and the operations on the ground. Thank you.
May I just follow up, Chief Justice? I thought you'd perhaps give us examples, Judge. For example, on the last occasion, Judge Makaula had commented that there were numerous backlogs, that there would be two roles in one motion court, that certain judges refused to work more than a certain period. Are those issues resolved?
I would venture the answer yes. Yes. The answer in a nutshell is yes. And as I've said, please don't panic about Eastern Cape. We learned from that unhappy experience. When we woke up to it, we regrouped, we made the situation better for the division and the Republic.
Thank you, CJ.
CJ, my follow-up question, I'm here, because
Thank
my
you.
question was on the
Yes,
same point.
yes.
Yes, I'm taking a follow-up question, CJ, now because my question was on the same point. Thank you very much, and good morning, Judge.
Good morning.
It is correct that you came under heavy criticism, that under your headship, you took light of the fact that there were some challenges in that court, in Mthatha court. And you said you did not have the experience of some of the things that were mentioned, or the challenges that were mentioned. And I've been listening to your answers or responses to the question. I then said to myself, part of leadership is owning up to your own mistakes. Now, we are in 2023. With the benefit of hindsight, did the criticism have any basis at all? Thanks.
The fear I have is that raking the ashes of the past, I'm not referring to the meeting, Commissioner, and what was discussed there, because what was discussed there had a foundation to the history. It was, in actual fact, less about me, because I just acted to fill up the post for momentarily until the new incumbent was appointed. So I'll attempt to just say, I do have that fear, but I owned up, we owned up. We're not underestimating the importance of the discussions that we had. And if I recall on that occasion, what was referred to me as the attitude.
I'm sorry, Judge Nhlangulela. If, from what you have said, it appears to me that you are not going to say the criticism was without any basis.
No, I'm not saying
so.
So
If you are saying there was a basis for criticism, that should be an enough answer to his
thank
question.
You. Thank you. I've said as much to the previous commissioner as well. That's exactly where I'm located, Commissioner.
Thank you very much, CJ.
Thank you. JP?
Thank you very much, CJ. Good morning, DJP.
Good morning, JP.
I had a number of questions, but I'll just focus on one. It's ground that has been traversed a bit, but this relates to a matter you had in Gauteng that involved the judge and this body, the JSC. It was a matter which involved the review of administrative action. Now, I didn't see you reflect this case in the cases that you think were most significant, and I was intrigued that I want to understand why. Is it because the SCA reversed you, or because you think it's simply a matter of the run-down-the-mill matters that you would have come across in the Eastern Cape? So it's those two. I don't need an explanation. I just need to understand that.
JP is vulnerabilities. I must be honest. I'm human at the end of the day.
Yes.
I become fearful at a certain point. It's not a question of concealing, but the judgment is there. It's known by the entire Republic. And I know what I did in that case, JP. I know exactly what I did in that case. What I did is this.
No, you don't have to explain.
Oh, thank you very much. I know what I did. Yes. I did the job well, but you know, if you're a human, you'd fear that, hey, you know, and the state of politics. I think I was more than anything being protective to the judicial. I didn't want us to open a discussion which is, you know, it has got those undertones about which I feared. Pardon me about my weakness. That's part of my weakness. I tend to fear at times, but not that I cannot explain. It. So that was a very important case, and I know that it is known, whether I reflect it here or not. It's part of the many cases that I've decided. By the way, there would be other very good cases I've decided.
Let me stop you there.
Yes.
You say it was an important case.
Very, very important case. Yes.
Okay.
Yes.
No, I think that's what I wanted to know. But the last thing I want to say is a comment. I want to thank you for having agreed to come to Gauteng to help us deal with these type of cases. Thank you very much, CJ.
Thank you.
Thank you. So Judge Nhlangulela, are you saying the reason why you didn't put the case up, although it was very important, as you said, because you were fearful of something?
How do I put it? I've said it's a vulnerability and protecting the platform such that it does not get derailed into areas which, in my opinion, I might have assessed this wrongly, I concede. But I said, hey, you know, I must approach this meeting less about any controversy, not specifically controversies arising, political controversies arising out of this case. It's not a question of concealing. it's in my nature. I'm too protective at times. Even when people call me names, I tend to keep quiet. It's in my nature. But one thing I know is that I don't betray human beings. I still believe that I'm fit and proper to be a judge, to preside, even in the SCA. Thank you.
Thank you, Judge Nhlangulela. Commissioner Moiman.
I'm covered, SJ.
Thank you very much. Commissioner Nochesi.
Thank you, CJ. Justice Nhlangulela, to take time, not to waste further time, the Chief Justice greeted you on our behalf. If you look on your letter of nomination for Painadel, it's under the heading Justice Nhlangulela as a jurist. And then, look, I can read, if you don't have, I can quickly quote from here, where it says, our members make use of his judgment as authority in other courts as well. We admire his self-discipline and discipline he commands to maintain decorum of the court. Of course, we have known him as a disciplinarian from way back in 90s when he was practicing an attorney in the then Transvaal and broader South African, goes on as a member. Now, there's a question that what contribution have you made? What do you say to this statement that in the early 90s, you were already a member of NADEL and involved in the things that I mentioned? How do you link that up with your contribution in the community and yes?
Thank you, Commissioner Mutesi. This is without doubt a realistic reflection of my background. And I maintain that my contribution far exceeds that of my contemporaries on the bench. That's what I may say. I'm a true member of the judiciary. I did not lie with the oath that I made. It's because of these things. And I like it more when the assessors speak of me. I can't say more. I can't say more. But I agree with this. That is why I decided that it is proper. It would have been improper for me not to avail myself for this interview and for this purpose, given this background.
Thank you,
because
Justice.
many of my colleagues don't have this background.
Thank you, Justice. And now there is this debate about the application.
Please do raise your speak up so we can hear.
There is this debate which I also hear you to an extent conceding that you might not have applied principles of parture and the Constitution. As I understand, you have been a judge for 14 years and you are one of the presiding officers in the full bench as a senior judge, second senior judge in the Eastern Cape. To what extent is this statement correct that you might not be aware of parture, which is the reviews is what is an order of the day in a court, or is it just that maybe other persons?
Sorry, Commissioner Jesse. I don't think anybody suggested that he's not aware of it.
Okay, let me put the question differently. What I'm saying is, question of judgment writing differs, let's put that way, and how one writes judgment. The fact that in a particular judgment, you have not elaborated about parture, would it mean that you don't know how to apply parture?
I'll submit not. It doesn't. It, I would ask the honorable members of the House to take that into account. You know, human beings present themselves in many ways. By the way, I received training. And I agree with CJ. It's not that I'm saying I did not study administrative law. I don't know, and that's not what I'm not conceding to that. All I'm saying is that I consider I might not have amplified in my reasons. And then I've said, but look at the outcome. I did not send the innocent man to jail. I did not send the innocent man to the gallows. The reason is, when you write a judgment, a lot of principles, they occupy your mind. You can only miss them on the pen, but one thing that will never be mistaken about is the outcome, yes. Even if you have not elaborated on other things. That's the judgment style, that's how it goes. It's not negligence, it's not incompetence, it's not anything adverse, but I'm not opening a debate. All I'm saying is that this is how judgment making goes. And this one was made by a person learned who passed at university, who knows what these things are about.
Thank you, Judge Nhlangulela. Commissioner Baloyi, do you still have a question?
No, I have dealt with my issue.
Follow up.
I'm sorry? Who is it on the? Oh, okay. Is it Commissioner Barnard?
It is Marumo Akai.
Oh, yes, please follow up.
Judge, I'm sorry, I will have to push you a little bit on this point because it unsettles me a bit. This point was raised earlier on and it's now raised again. When a judge writes a judgment, I understand that at the High Court level, perhaps maybe the workload is extensive and at times you might not have sufficient time to really reflect on the matter and then do justice to the matter. Yes, the outcome matters, but the approach and the reasoning, they equally matter because we have students that we teach out of these judgments and we have the entire legal body that looks at these judgments for precedent. So I just want to understand your view in respect of the building up of a judgment from a reasoning point of view. How important is the reasoning? In other words, the way you understand the facts and how you apply the law and engage the law to arrive at a conclusion that because the conclusion might be right, but what now we are debating with you is the route that you took to reach the and I think that is the debate that unsettles me. Thank you.
I'm about to tell you something, Commissioner. When the Concord was confronted with the controversy that divided the court, I think this appears in the judgment. When I read that judgment, there's a lot it did not say, but I understood the outcome. There's a lot it did not say, I understood the outcome. And the outcome was steps are going to be taken against Judge Hlophe. The sitting was compromised because those who sat were implicated in one way or the other. It's an official judgment. There's not a lot. There was even nuances when it came to the procedural aspects of litigation. But I understood as a judge why the Concord did that. I can't blame it. I knew what it was doing. What I'm trying to say, Commissioner, is that in deciding these matters, there may be 1 point or 2 points or that are not amplified. But believe me, if you are a judge, there's a lot that runs through your head. And that is why the outcome matters.
Yeah, but the question is the reasoning not important?
No, it is important, CJ. I'm with you, it is important. It is important. I'm not debating.
Yes.
From the beginning, I don't want to be understood as expressing myself within the confines of a debate. No, I'm not. Valid points for discussion are taken. I accept that.
Okay, no, that's fine. Commissioner Marumoahe, are you?
I'm satisfied, CJ.
Yes, okay, thank you. Commissioner Singh? Let me just say, commissioners, we have taken 2 hours with this candidate. So if you still want to ask a question, just reflect on how important it is for you to ask the question. Commissioner Singh, you say you are covered?
I think that was an appropriate intervention, Chief Justice. I am covered.
Okay, thank you. Thank you. Commissioner Bernard?
Thank you, Chief Justice. Shortly, Judge. Good morning, Mr. Nhlangulela. My question is just about the exercise of discretion and how you explain that in the judgment. And I'm referring to the Collar Reserve, the customary law judgment. So what you do is you exercise your discretion, you say cost follows the result, and you then say it bears mentioning that the first to the fourth respondents all opposed the matter. And then when 2 paragraphs later, when you make the finding, you actually find only against the first, third, and fourth respondent to pay costs jointly and severally. The second respondent doesn't then feature. The second respondent in that matter was the chief, if you'll remember correctly. So the question is, how did you exercise your discretion to exclude the second respondent to pay costs? And do you not think it was maybe necessary to explain that in the judgment as well, for the benefit of those that must read it? Thank you.
A decision on course is the exercise which is founded on the discretion of the court. The discretion is not whimsical, even in this case. I did not whimsically decide that the chief must not pay the cost. It's founded on principles. What was in front of me was an administrative matter in which the premier was the heart and the engine of this litigation, which he could have prevented. Okay, that's the genesis of the cause. So my thinking was, I'm sure that the premier, for having lost the case, must pay the cost. And the people against whom litigation happened were ordinary members of the community. I'm trying to say not situated in a department and so on. Now, when you decide a course in a case such as this, given the outcome of it, I then thought that since the chief is part of the office, the administration, the process of appointment, as it were, and having been under the protection of the premier, the case was less about him, but it was more about the mistaken step taken by the incumbent, because the person who decided, it was the premier in terms of the act. So that's how I excluded the chief. It is on that consideration. And when you talk about costs, you have to situate the parties very carefully. It's easy to start a case and say, hope, let's fight. But you can determine that the origin of this litigation, we call it lis in Latin, it starts here. And it had to end right there. That's how the discretion on course was applied in this matter. It's not out of step. It's informed by the lis, the litigation, the point being litigated. Thank you.
It's just that you identify the 4 respondents that oppose the judgment. You say cost should follow success, and then you make a cost order not against the Premier alone, but against 3 of the 4 respondents. So that was, but I'll leave it at that. If you want to comment, you can make comments. Thank you, Chief Justice.
Yes, thank you.
Thank you. Commissioner Nhlangulela.
No, Chief Justice, I listened to what you did not say, so I'm not asking my question.
Okay, thank you. Thank you. I think we have come to the end of the interview. Thank you very much, Judge Nhlangulela. We appreciate your making yourself available. You are now excused.
Thank you very much, Chief Justice, honorable members.
Thank you.